All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. We're here today in our case Wednesday ACR 16-0391, State v. Nixon. Each side will have 20 minutes to present their argument. Appellant, you may reserve any portion of that you want for rebuttal, but you'll have to keep track of that time yourself. That's why we have the clocks at the podium. We are recording the argument, and in a couple of days the argument should be up on YouTube. So, because we're recording this, when you begin your argument, please identify your client and yourself so that we can keep everything straight. We've read the briefs and the record, and we've conferenced the case, so we're familiar with everything. So when you begin your argument, just launch right in to what you want to talk to us about. Counsel, you may begin.
Carr Maley for appellant. May it please the court?
Yes, please.
Appellant was charged with an offense that occurred in August of 1986, entered an Alford plea to that charge, completed 15 years of probation, and was successfully discharged in 2002 with no priors, no problems on his probation, during his term of probation. The legislature passed a statute effective in 1994, which would increase the loss of rights that Mr. Nixon suffered because of his conviction. At the time of his conviction in 1986, or his conviction was in 1987, the offense was 1986. The punishment, of course, is fixed by the date of the offense, 1986. At that time, the statute in Arizona provided for a loss of certain civil rights, hold office, vote, serve as a juror. There was nothing at that time about loss of firearm rights. 1994, effective date, I think April 1994, the legislature amended that statute as to loss of rights to add the loss of firearm rights. In that statute, the legislature did not expressly state anything about retroactivity. It said nothing about retroactivity, which under the Arizona statutory scheme means that it is not to be applied retroactively. And there is no need to interpret legislative intent. Under the Arizona law, if that statute does not say it's intended to be retroactive, it's not retroactive.
Well, Counsel, a concern I have with your argument is that I'm not convinced that the statute is being applied retroactively for all felons who have had their rights restored as of the effective date of the statute in 1994. It changes the consequences of that current status. It doesn't seem to reach back to change the consequences of that prior conviction.
Your Honor, this is not a matter, I'm not certain that this will answer your question, but this is not a matter of reinstatement of rights. This is a question of what rights were ever lost to begin with. The loss of firearm rights was never lost. So,
well, as in 1994, like you said, all felons as of 1994 lose their right to possess guns. So, and that's that applies prospectively as of the effective date of that statute. It doesn't seem like it reaches backwards.
It does not reach backwards. Is that what you're saying?
Yes.
Well, I agree with you.
Then if it doesn't reach backwards, then there's no retroactivity problem there. For there to be a retroactivity issue, the statute has to apply backwards, and I don't see how it does apply backwards.
Well, this is that's the problem. The court applied it retroactively. Mr. Nixon made a mistake by applying in 2007, applying to have his rights reinstated, which he didn't need to do. And then in 2016, we filed an application because of that prior order. If Mr. Nixon had never done anything, it's my position that he would have never lost his civil rights, including his firearm rights. But he applied pro per erroneously, and the court denied his rights. So we had a court order out there saying all your civil rights are denied or revoked.
But it seems like his right to possess a gun was legislatively abrogated as of the effective date of the statute in 1994.
All right, that is the case law we've cited. The question is, what is the last event? What is the significant event which would have caused him to lose that firearm right?
And I guess my understanding is that his status as a felon in 1994 would be the operative event.
No, status as a felon doesn't do it.
And why not?
You cannot take a status of having committed a crime before and then change the punishment for that by saying, well, we're just changing his status and adding more punishment.
Are you aware of a case from the Arizona Supreme Court, Zuther versus State?
Yes, sir.
As I understand that case, the legislature changed the gate money statute as of 1992, I believe, and that the Supreme Court said that was not a retroactive application for inmates who were convicted before 1992 because it applied to all inmates all persons who had the status of an inmate as of the effective date of that statute. It changed the way the inmates were entitled to gate money. So I don't see how that's any different from this case.
In Zuther, Your Honor, the court said that the critical issue in retroactivity analysis is identifying the completed event. So you can say you have a felony conviction, and in the future, if there's another event, some other event, another offense, if you reoffend, then the penalty is going to be changed, it's going to be increased. But you can't increase the penalty without any additional completed event.
What was the completed event in Zuther?
Well, I don't remember the case facts specifically, although the court did say a statute is not retroactive necessarily because it relates to antecedent facts, such as the status of having been a convicted felon. But retroactive application does more than relate to those antecedent facts. It makes the appellant a felon whose right to possess a firearm was suspended. Now, in other words, the court said that the application of that statute alters the legal consequence of the original conviction. What I'm saying is you cannot say because the guy has a felony conviction, now we're going to change the punishment for that conviction. We can say if he has a prior conviction and has the status of a felony offender, then if he does something else, if he reoffends after the effective date of the statute, his punishment can be enhanced.
Can't a judge add new probation conditions?
Well, there are some cases on that. That's more. The punishment for a probation violation, of course, is punishment for the original offense. It's not punishment for the probation. So that gets a little more convoluted. I couldn't, without the facts, I couldn't really comment on
Well, there
that.
usually has to be, notice and a chance to be heard, but, I mean, the statute arguably provided the notice and, a right to be heard. If you know what the statute is doing to you, he could have gone into court and said, you can't apply this to me. So you could look at it as just adding a new condition to an already existing probationary term.
Well, you can say, yes, if they could have said, you lose your firearm rights if you commit another offense.
Yeah, but probation officers sometimes just decide if somebody needs some other condition, and they don't necessarily even have to go to the judge to do it. But
Okay, so the statute could say if you reoffend in any way, a probation violation or another crime. Here, Mr. Nixon's been a model citizen since 1986. He's done nothing more. And I think it's pretty clear, as Justice Martone said in 1999, the legislature can adjust for the future, but they can't adjust for the past.
well, what about this old Vera case? Doesn't that sort of already say that this is not a retroactive
The Alvera case,
case?
I believe, was an ex post facto decision. And
It did involve that.
And so first thing you do, and whether you're going to follow retroactivity or ex post facto, is you check on retroactivity first. But you never get to ex post facto if you properly analyze it with retroactivity analysis.
And Counsel, I
In
agree.
other words, you look to see if the statute's attempting to reach older conduct, and then you have to consider whether it's an ex post facto.
Yes, then you go to the constitutional issues, whether it creates a new crime or increases punishment for a crime. But you don't, the cases, several cases say, in terms of retroactivity, we never get to that point, ex post facto. It's not that difficult.
Counsel, I understand that the primary discussion in Olvera was ex post facto, but it seems to me that the court also said that the amendments were not applied retroactively, but only prospectively.
The Alvaro decision was hard for me because I don't know the facts. I don't know the record. Because at the end of that decision, the court says he's being punished for something he did after the effective date of the new statute. So I'm not sure exactly what the facts were in the case that I could comment on, except to say that I believe it was an ex post facto only. And
I'm page 76 of 181 Arizona. The court says that the statute is applied prospectively, not retroactively. At least that's my reading of the statute. Of course, I could be wrong.
Well, Your Honor, one quote I find in front of me here is there was no retroactive application to Alvera because he was only being punished for conduct that occurred after the effective date of the amendments. Therefore, and of course I have no quarrel with that. That is absolutely correct.
But if it changed the consequences of it, if the statute depends on the status of a person at a particular date, then that's still a retroactive application?
If the statute imposes a new penalty without any additional offense or any other additional conduct, yes.
Like you pointed out, some of these probation issues are kind of multifaceted, but I seem to recall at one point there was a long discussion about whether probation was even a sentence. And I believe that we end up that probation is a feature of sentence or a feature of sentencing rather than a sentence itself, because it's technically a suspended sentence. So I guess there's even a question about whether conditions of probation are even punishment.
I remember some of that dialogue, and I think it's a condition of a sentence, I believe. So I don't know how that helps us here.
Whatever that means.
Maybe it does. But my point is that, the legislature can say you have this status that you earned for yourself with a prior conviction. Now, if you do something else, it's going to be tougher on you than it was before. Now, if you do something additional, you're going to get an enhanced punishment. But if you do nothing else, we can't say, hey, way back in 1986 you did something, and now, guess what? It's going to cost you more than it did at that time. Are there more questions? I'm happy to.
No.
I mean, I don't know how else I could say that's our position.
It strikes me that it would clearly be a retroactive application and probably an ex post facto application if in 1993, your client had possessed a firearm, then in 1994, his right to have a firearm was denied, and then somebody attempted to prosecute him for being a prohibited possessor as of his 1993 conduct. That would clearly be a retroactive application and probably an unconstitutional ex post.
I think that's a harder case for me, but I think you're right. It's also, my case is much easier than that.
Yours is different.
Because he did nothing.
Yeah.
But if he had done something illegal before 1994, still it wouldn't have made any difference as far as retroactivity.
Another way to look at it is the effect of the 1994 statute was to just say that heretofore, here on out, he's a prohibited possessor, and it will be a crime for him to. So I mean that would just be creating a new crime basically with a new definition.
Well, that would be sort of what I'm talking about. If he reoffends at that point forward, then he's going to have.
No, but I'm saying offends by possessing a firearm. I mean, under your theory, they wouldn't be able to charge him even prospectively in the future.
I don't think they could do that either.
Yeah. And I think if you look at it as just, in effect, the legislature just creating a new category of offenses, that they certainly can do as long as it only applies for the future.
Well, with separate punishment for those offenses. Not for the offense in 1986, but offenses for the new crime. If there are no questions, I'd like to save some time. Do you have questions, Judge?
No.
I'd like to save some time.
I appreciate that.
Thank you.
Mr. Grant?
Good morning, Your Honors. May it please the Court. My name is Jerry Grant, Deputy County Attorney representing Appalachia, the state of Arizona. Perhaps to make our argument or our position fairly brief, our position is that the Olvera case controls here. In fact, the Olvera case is even a more serious offense than what we have here. In Olvera, the defendant was convicted of misconduct involving weapons based upon a subsequent change regarding his convicted felon status that prohibited from having a firearm. He made the same sort of argument Mr. Nixon is making here. And the Court of Appeals rejected it. And as Judge Howe pointed out, the Court of Appeals did both a retroactivity and a ex post facto analysis.
So was Olvera then being prosecuted for being a prohibited possessor?
Yes, he was convicted of misconduct involving weapons based on.
Was that the appeal that was decided in that case?
Correct. Yes.
So that's as opposed to violating his probation based on a new condition imposed by the statute?
Correct. In Olvera, he was found guilty of aggravated. What he did was he was playing with a loaded firearm. The gun discharged and hit his girlfriend in the hand. His small children were present. He was convicted of aggravated assault, 2 counts of endangerment, and misconduct involving weapons.
Okay, but so it'd be one thing to say you can or cannot punish him for the new crime of being a prohibited possessor. But what if they'd gone back to revoke his probation on the old one? Mr. Maley's argument is maybe they could do the first one, but they couldn't do the second one.
Well, if they could do the first one, I don't see what the problem is here. He's not being charged with any crime. The statute is not being applied retroactively.
His argument would apply to my framework of, well, if all the legislature's doing is creating a new definition of a crime, and that a person who's a convicted felon is not allowed to possess a weapon from 1994 on, and after 1994 on he possesses a weapon, then it's clearly prospective. But if they tried to go back and violate his probation, that's adding new consequences to his old offense.
I'm sorry.
I think Mr. Maley's arguing you could maybe, if you could do the first one, you still can't do the second one.
I don't see the effect of going back here. Mr. Nixon's status as a felon is affected only going forward from 1994. He was not charged with misconduct involving weapons, involving any conduct he might have had prior to 1994. All we have here is a request to restore the firearm rights. I disagree with Mr. Nixon that I disagree with counsel that his right was never lost. It was lost in 1994 when the statute was enacted. And therefore, in 2002, when his probation was discharged, he had to apply to have that right restored.
So he could have possessed a firearm at any point, even though he was a felon, at any point up until the effective date of the statute without any criminal consequences.
Correct.
Correct?
Correct. From the time of his conviction, at the time of his conviction, the statute did not provide for loss of the right to possess a firearm. So he could have possessed a firearm at any point from 1987, which I believe was the date of conviction, up until 1994, when the statute was added, the subsection was added to the statute. He could have possessed a firearm during that period without any consequences.
So his disability that prevents him from possessing a firearm was based on his status as of the effective date of the statute, not as a consequence of his criminal act in 1986 or conviction in 87.
Correct. The state also relies on State versus Noble, which dealt with sex offender registration. And in Noble, the court, and that was the Supreme Court, it did not involve a conviction as Olvera did. He was simply complaining that the sex offender's registration requirement should not apply to him because his conduct occurred before the enactment of that requirement. And in the ex post facto analysis that the Supreme Court did there, they acknowledged that there is an ex post facto effect, but it also discussed if that is true, you have to look at whether the effect is punitive or regulatory. And in Noble, they concluded that although there were some punitive aspects of the sex offender registration requirement, on the whole it was a rational, now I forgot the term that I want to use, it was a rational application of the legislature's ability to regulate who they want to, and to allow law enforcement to recognize who has been convicted of a sex offense. The same logic,
Well, I mean,
I think.
that sounds similar to my comment that probation officers frequently add new conditions of probation in terms of to aid in regulating a particular probationer's conduct, because probation has this sort of amorphous status of it. It's a suspended sentence, so it's, although it has punitive aspects, for example, if you put them in jail for 6 months as a condition of probation, that sounds punitive. Some of the other stuff is clearly regulatory. So I don't know if you look at it as this just another regulation of probation, then it doesn't fit very easily into the whole ex post facto scenario.
I agree with the analysis. In Olvera, that's what the Court of Appeals wound up finding, was that the legislature had a reasonable basis to determine that certain people, essentially convicted felons, should not be possessing firearms.
But it just seems to me that, a lot of this kind of question, you could look at it sort of in the abstract metaphysically, but how you frame the action seems to sort of invite the answer. As Judge Howes says, maybe all they're doing is regulating the rights of persons with certain statuses from the date of the statute into the future. If the legislature decided that, put aside Second Amendment considerations, if the legislature decided that non-citizens, as of the date of a new statute, could not possess firearms, could you say that, let's say they said that persons who are non-citizens and who are in this country illegally, after an illegal entry from another country, they can't possess weapons. Would you say that could not be applied because it's an extra consequence of the initial violation of coming across the border illegally? I doubt that.
I doubt that as well. I think what happened here was when the legislature enacted subsection 5 to 13904, essentially all that happened was that Mr. Nixon's status was changed going forward. From that point on, he could not possess a firearm based on his status as a convicted felon.
Mr. Maley characterizes that as not just punishing his current status, but applying a new punishment to his previous conviction.
That is his argument, but I think Olvera rejects it. Unless the court has additional questions, I'd rest on the arguments made in the brief.
Thank you, counsel. Counsel?
Yeah, I'm curious what you think about this, the argument about Noble, that by requiring sex offenders to register, even though they were previously convicted, that apparently the Supreme Court decided that was not at least it was an ex post facto. I don't know if they talked about retroactivity or not.
In the Noble case,
Right.
I think that the court can change the status, but there's no punishment next to that.
Well, that's apparently what they said. It was a regulatory thing,
Yeah.
not a punitive thing.
Depriving him of his Second Amendment right is not a regulatory thing. It's an additional punishment added on to the loss of civil rights.
Well, how do you address Judge Thompson's hypothetical with the person who has entered the country illegally? If the legislature passes a law that says if you've entered the country illegally, it's illegal for you to possess a firearm, are we reaching back to add punishment for the person's illegal entry, or are we just regulating the consequences of the person's current status?
It would depend on what the second statute is. Is it a crime because he's already been convicted of a prior offense, and the legislature's now created a new crime with a new punishment?
Okay.
That's a totally different thing. The guy who comes in after being convicted, he's convicted of illegal entry, and then he's on probation or he's whatever. He's completed his sentence or completed his probation. And the legislature passes a statute that says if you have been convicted of illegal entry, you can't possess a firearm. Then he does another act. He possesses a firearm.
Yeah, but supposedly, he's, let's say he comes across the border in 2010, 2017, the legislature passes the statute we're talking about. He never convicts any crime at all except that he owns a gun. Let's say he owns a gun in 2016, and then they pass a statute in 2017 that makes it illegal for him to have that. He says, oh, even though I wasn't convicted of it, when I came across the border in 2010, it wasn't illegal for me to have a gun, so you can only apply the punishments that existed when I committed the crime. So my answer to that would be, well, he's being punished for his current status going forward, not the fact that he crossed the border illegally in 2010.
Well, it's a new crime. It's a new crime that's been created in a new punishment. It's not a retroactive punishment for the original offense. In other words, he did something more, and they're not reaching back and saying he crossed in 2010, and guess what? Now you can't have a gun either, or if you do, it's a crime. It's not punishment for that. It's a new offense.
But under that Noble scenario, couldn't it be considered regulatory in nature, that we're the reason we don't want a convicted felon to possess a crime, and we want to make that basically a new condition of probation, because that we think that would contribute to successful completion of probation, or on some basis?
You mean an additional condition of probation?
Right.
That's
sort of what it's like.
I don't think I can get in those weeds, Your Honor, but there is, in ex post facto analysis, it's a little different. There is some judge-made law, some case law about regulatory versus substantive in ex post facto analysis. But you don't even get to that if retroactivity analysis is sufficient. And in this case, it is. Clearly he did nothing more And now they're tacking on more punishment for what he did in 1986, or allegedly did, but under a Alford plea. Again, as Judge Martone said, they can adjust for the future, they can't adjust for the past. And creating a punishment for a status with no further activity violates the retroactivity statutes. Are there any questions?
No.
Thank you, Your Honor.
Thank you, counsel. We appreciate your arguments today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned. Thank you.